Hello everyone. Today we are going to see an interesting topic which is intellectual property right. This e-content is prepared by SV Nandita Krishna. Now let's know what intellectual property rights are. So they are the legal rights that protect intangible assets like invention, artistic works and brand names. These rights enable the inventors and the creators to have control over who can use their inventions or creation for a specific period of time. They are owned by individual or company and they are protected from unauthorized users. Here are the types of IPR in India. They are patent, trademark, copyright, plant breeder's right, utility or model design, geographical indication, trade secrets. Alright, now we'll see the types of IPR. The first one is patent. Patent is a special right or an exclusive right given to the inventor of something new. It means that only the inventor can decide how their invention can be used by others. In return to this right, the inventor has to tell the public about their invention by publishing a document called patent. So, this document has all the technical details about the invention. The protection is granted for a limited period of 20 years. Now let's move to the types of patent. There are three types of patent: utility patent, design patent and plant patent. Utility patent is a most common type of patent and it covers the invention or discovery of any new and useful process. It can be machines, manufacture or composition of a matter. The second one, which is a design patent, covers the ornamental design of an article of a manufacture. And the plant patent is a type of patent that covers the new variety of plants in an uncultivated state. I hope that now everyone must have understood what patent is. Now let's see the merits and the demerits of patent. The merits of patent is that it offers an exclusive rights which gains in a competitive advantage and higher profit for the inventors. The second one is that it is an incentive for innovation as it encourages investment in new products and processes. And it also promotes further innovation and technological progress to the public. The demerits of patent are: the first one is because of the high cost. It is expensive for small business and individual. The second demerit is that it is time consuming because the application process is lengthy and it delays the commercialization. The third one is a patent troll as some exploits the patent for lawsuit. Now let's shift to the next type of IPR, which is a trademark. A trademark is a distinctive sign or symbol that indicates certain goods or services as those products provided by specific person or the enterprises. It may be one or combination of words, letters, numericals, drawing, symbols, three-dimensional signs, audible signs, fragrance or colors. The initial term for registration is about 10 years. There are two types of trademarks. One is the word mark and the other one is a device mark. A word trademark consists of words or combination of words, whereas a design trademark consists of logo, design or other visual elements. Some trademarks have combination of both word and device. For a better understanding, I have attached few trademarks. The first one is a logo trademark of the brand Nike, which consists of a symbol. The second one is a combination of both symbol and words of the company Samsung. The third one is a device trademark which consists of symbol and words. Now let's move to the third type of IPR, which is the copyright. Copyright is a legal term describing rights given to the creator for their literary and artistic work. So this right grants the creator of the original work the exclusive right to reproduce, distribute, perform and display their original work. So this protection is automatic and arises as soon as the original work is created and fixed in tangible medium of expression, and it provides additional legal benefits and protection. The kinds of work covered by copyrights include literary works such as novels, poem, plays, reference work film, musical composition and choreography, artistic work such as painting, drawing, photographies and sculptures, architectures and advertisement, maps and technological drawings. Penalties can include damages and injunctions. This slide consists of an in detailed example of works that comes under copyrights. To make a clear vision of this topic, I have a question for you all. Have you heard about Kanchipuram saris of Tamil Nadu or Madhubani paintings of Bihar? All of these are unique products from a particular location. This is termed as geographical indication, which is a type of IPR. Geographical indications are the signs used on goods that have specific geographical origin and possess qualities or a reputation that are due to the place of origin, and it identifies a product as originating from a particular region where the quality, reputation and other characteristics of the product is essentially attributable to its geographical origin. The use of GI also promotes and protects the traditional knowledge, skill and cultural heritage associated with a particular product or region. Here are some geographical indications of India, such as Hyderabadi Dum Biryani, Madurai Jigardanda, Gujarat Garchola, Darjeeling tea, Lakadong turmeric of Meghalaya and Mysore sandal soap. Here comes the next type of IPR, which is an industrial design. An industrial design refers to the ornamental or aesthetic aspect of useful article, which include shape, configuration, pattern or ornamentation that may be applied to an article. So this makes it more appealing to the eyes. This exclusive right prevents the unauthorized user to copy or imitate the design of the article. And this protection is usually between 10 to 25 years. Industrial designers are further divided into three types. The first one is two-dimensional industrial designs. So this is applied in articles such as textile, wallpapers and patterns. The second type is 3D industrial designs. They are applied on furniture, electronic devices and automobile. The third type is graphic symbols, which includes logo, icons and other graphic designs that identify a particular product or service. Now let's see an interesting type of IPR, which is a trade secret. So it may be a confidential business information that provides an enterprise a competitive edge that may be considered as a trade secret. Usually they are manufacturing or industrial secrets or sometimes a commercial secrets, which may include formula, processes, designs or other valuable information about sales method, distribution method, consumer profile, advertising strategies, list of suppliers and clients, and manufacture process. This is contrary to patent, as trade secrets are protected without any registration, as we saw in patent. The four types of trade secrets are as follows. The first one is formula and recipe, which are confidential information of food and beverage industry. The second one is a manufacturing process, which consists of the proprietary techniques in automobile and aerospace industry. The third type is the consumer list and marketing strategies, which are sensitive business data in retail and services. And the fourth type is a software or algorithm, which has a confidential program in tech industry. At last, we have come to the final type of IPR, which is semiconductor integrated circuit. Integrated circuit are semiconductor based component which contains integrated miniature electronic devices like transistor and resistor. So they enable compact, fast and efficient electronics which revolutionize the industry because of their high functionality in small spaces. So the aim of the Semiconductor Integrated Circuit Layout Design Act of 2000 is to provide protection of intellectual property right in this area. And the main focus of this act is to provide routes and mechanism for the protection of IPR in chip layout design created and the matters related to it. I hope that everyone must have understood what I have taught till now about IPR. Now let us see some IPR Act in India. The first one is the Patent Act of 1970, which regulates patent grant including filing, examination, infringement and compulsory licensing and revocation. The second IPR Act is the Trademark Act of 1999. This governs trademark registration and protection and addressing issues like infringement, passing off, and owner's right. The third one is the Copyright Act of 1957, which provides copyright protection covering registration, infringement, and Copyright Owners Act. The fourth one is the Design Act of 2000, which protects industrial design through registration and enforcement mechanism. The fifth one is the Geographical Indication of Goods Act of 1999, which secures geographical indication, ensuring protection and misuse. The Semiconductor Integrated Circuit Layout Design Act of 2000 is a final IPR act which regulates the protection of semiconductor layout design. And that's a wrap on this topic of intellectual property right. I hope that you guys would have learnt something about IPR and it would be helpful for you in your life. Thank you for listening. Have a wonderful day.